I call the March 11th, 2026 meeting of the House Public Safety Committee to order. A quorum is present. Before we begin our meeting, I want to remind everyone that the committee chair maintains control of this hearing, and I have the following expectations. Signs and placards are not permitted in the hearing room. Verbal outbursts, shouting, or disruptive behavior will not be tolerated. Applause and other audible demonstrations are not allowed. For safety reasons, sitting or standing in walkways and aisles or standing or obstructing at your seat is prohibited. If you require any accommodations, please speak with our sergeant staff identified by the gold ties. Troopers and House security personnel are present to ensure everyone's safety. If you receive an entrance ticket, please retain it as it may be required for re-entering if you leave the hearing room. Failure to comply with these guidelines may result in the removal from the hearing room. Thank you to the sergeant staff who are present for helping maintain decorum in the committee room. Chair Moeller, have you read the minutes of the March 11th, 2026 meeting?
I have, Mr. Chair, and I would move them.
March 10th meeting.
I have, and so moved.
Chair Moeller moves approval of the March 10th, 2026 minutes. All in favor signify by saying aye.
Aye.
All those opposed say nay. Motion carries. Minutes of the March 10th, 2026 meeting are approved. The first bill on our agenda is House File 3489. Chair Bennett, please come to the testifier table with your testifiers. I will move House File 3489 before the committee with a recommendation that it is re-referred to Children and Families Policy and Finance Committee. Chair Bennett, I see you have an amendment to the bill coded A3. I will also move your amendment before the committee. Please explain your amendment.
Thank you, Mr. Chair, and thank you, Public Safety Committee, for allowing me to be here. And I have to say, in my 12 years, I don't think I've ever come before the Public Safety Committee. So thank you, and it's good to be with you all. So this amendment is actually more education related. It just gets the bill into shape after working with a number of stakeholders, including Education Minnesota and Department of Children, Youth, and Families. I won't go into it because it's education related, so would love to have it added to the bill.
Chair Moeller.
Thank you, Mr. Chair, and thank you, Chair Bennett. I do have a question about the amendment. Just on line 2.1, it is talking about having training on grooming, and I guess I don't know that there's a definition referred to as grooming there, and I'm fine adopting this amendment, and I can save my comments for the larger bill as well, but grooming can be, like in my experience as a prosecutor, grooming can be a lot of what seems like innocent behavior too. Giving someone gifts, taking them out to dinner, like trying to sort of ingratiate yourself to your future victim. And so I know what you're trying to do in your bill with the definition of grooming is very different from that and illegal activity. And so I just didn't know with your amendment here, I'm assuming you're referring to the type of grooming that you're creating as a crime in the public safety bill. And so maybe just a suggestion is to reference grooming as defined in the bill that we're about to hear, if that makes sense.
Chair Moeller, you're aware of the grooming definition on page 7.3 of the underlying bill?
Yep, that's right, Mr. Chair. I think it would be great to have a cross-reference for this amendment to that definition that's in the actual bill.
Representative Bennett.
Thank you, Mr. Chair. And very good point. This is referring to the grooming definition in the underlying bill here. So I made a note there. I think that's a great idea.
Thank you.
Chair Moeller.
Nope, thanks so much.
Any other questions on the amendment A3? All in favor of accepting the amendment signify by saying aye.
Aye.
All those opposed say nay. Nay. Amendment A3 passes. Representative Bennett, to your bill as amended.
Thank you, Mr. Chair. And just to make good use of your time, I'm going to start with my two testifiers here. I have Hannah, and I'll let them introduce themselves later, and Detective Chad, who are here. I also want to recognize former police chief of Eagan, Roger New, who's here, and he had a part in kind of getting this bill going, so thank you, former Chief Roger, for being here too. But anyway, I'm going to ask them to just give the background. I would like the committee to understand why we're doing this. And then after that, I will ask your nonpartisan staff if they would just touch on which public safety components are we looking at for your committee. So if you're okay, we'll just start right in with my testifiers.
Have
Hannah
first testifier identified herself and begin her testimony.
My name is Hannah Lopresto. I'm a victim survivor of grooming and sexual assault by my high school band teacher when I was a student from 2012 to 2016 at Egan High School. Co-chairs Novotny and Moeller and members of the committee, thank you for the opportunity to testify. I'm speaking in support of House File 3489. As a high schooler, I played percussion and had the same band teacher each year. Early on, this teacher made me feel special by asking me to help him organize music or move instruments after class. Over the course of the 4 years, he slowly began to isolate me from friends and family, normalize touching me and communicating as if we were close friends. On an international band trip to Greece, this escalated to him showing a romantic interest in me, manipulating seating charts so I was always next to him on the airplane, pulling me away from the group on tours, and slipping a secret note in my suitcase. Back at school, he used religion as a form of control and made me believe that I had to marry him because of the things I had done. On the morning of my last day of high school, he sexually assaulted me in the band lesson room. He put his hands down the back of my pants and the front of my shirt. I froze and I cried. I graduated the next day, and the abuse continued into my early college years. Due to the years of grooming, I believed that I was an active participant in my abuse and that I had caused it to happen. I did not tell anyone the full story until Detective Chad Clausen from the Egan Police Department found me during the investigation into this teacher in 2022. My story exposed numerous gaps in our state laws that need to be strengthened to better protect K-12 students from sexual abuse, especially when it involves educator misconduct. This bill addresses many of these gaps, including the establishment of grooming as a criminal offense in sections 8 through 10. Often, when I share that I was groomed and sexually assaulted, most people focus in on the sexual assault as being the most horrific and impactful. But for me, the 5+ years of grooming were even more harmful to my long-term health and well-being. It was years of psychological manipulation that harmed my understanding of relationships, my own value, and my ability to trust others. Grooming is the creation of a false world made just for you. It lures you in by making you feel special, seen, understood, and then it preys on every vulnerability you have until you're trapped by shame. Shame wants you to hide, and hiding protects your abuser. At the height of its control, I would have done anything he asked. Grooming is not a precursor to abuse, it is abuse all on its own. Establishing the grooming of children as a felony can prevent this abuse from escalating to sexual assault, and it recognizes that grooming alone causes substantial harm to a child. Thank you.
First of all, let me say, I'm sorry that you had to go through that, and thank you for having the courage to be here and tell your story. Next testifier will be Chad Clausen, a detective with the Egan Police Department. Identify yourself and begin your testimony.
My name is Chad Clausen. I'm a detective with the Egan Police Department. Co-chairs Novotny and Moeller, and members of the committee, thank you for the opportunity to speak in support of House File 4389. I'm the detective who investigated Hannah's case. Although there were no criminal charges, that outcome was not due to a lack of probable cause. It was due to gaps in Minnesota law in 2016 regarding positions of authority in high school students. Some of those gaps were addressed in 2021, but many remain. Some of these are included in this bill. Grooming is a standalone statute. Appropriate relationships are the foundation of school safety between students, between staff, and between staff and students. Every student needs a trusted adult in their school. And our schools and community rely on teachers to cultivate professional, healthy relationships with their students. A teacher cannot accidentally groom a student. Grooming is the deliberate, slow process of building a false sense of trust with the child with the intent of making future sexual abuse easier, regardless of whether any sexual violence occurs. During the investigation, I observed deeply troubling and consistent patterns of deceptive behavior that followed a clear playbook to groom multiple students. The volume and content of the communication was alarming. I noticed similar phrases, themes, and tactics used by the perpetrator to manipulate and control numerous students. 12 states have already made grooming a minor with the intent to sexually abuse them a felony. Waiting until physical violence occurs allows more harm. This bill supports accountability and allows for early intervention, protecting students before abuse escalates. In closing, grooming is always intentional. One cannot accidentally groom a child. It is not a one-time event. Grooming is a process that can take years, revealed through repeated patterns of manipulative behaviors. Grooming is not a precursor to abuse. Grooming is abuse. Hannah endured over 5 years of grooming, a trauma that has deeply impacted her life, and still the perpetrator faced no consequences. These proposals are practical, preventative, and focused on child safety. They target predatory behavior, not educators. Thank you for your time.
Thank you. Committee members, please keep in mind that this bill came before the Education Policy Committee, and we are now hearing it in public safety because it includes the new crime of grooming and has criminal penalties. I would ask committee members to confine their testimony, questions, and comments to the section of the bill that is in the Public Safety Committee jurisdiction. Members, do we have questions for the testifiers or Representative Bennett after she presents the bill to start with?
Thank you. Thank you, Mr. Chair. And in just a minute, I'll ask if you're nonpartisan would just point out the sections that do have to do. But I would like to add and say thank you to both my testifiers. And I have had so many people email me from the state saying, thank you, because I experienced this. And even staff and members and everyone even around here. And so it's a much-needed piece of legislation. We want to get it right, though. We don't want, as Chair Mueller said, we don't want to loop in innocent behavior, but at the same time, target the behavior needed to be targeted. And I will add, one of the reasons I'm very passionate about this after listening to Hannah is I experienced this as a high schooler in 10th grade with my band director. He groomed me, and it was, I can remember it clearly to this day. It has impacted me, and I never talked about it for a long time. So it's personal to me as well as important to Hannah and every other girl and boy throughout this state, and thank you for hearing this, and we'll just ask nonpartisan if they just mention the parts of the bill that you're looking at.
Mr. Diebel.
Mr. Chair and members, the portion of the bill before the committee begins on page 7 with section 8, and that adds a definition of pattern to our existing statute on solicitation of children, and then moves on to section 9, which is the actual grooming offense. And then section 10 is the piece where it creates the felony penalty for the grooming offense.
Members. Questions for the testifiers? Representative Curran.
Thank you, Chair. Not so much a question, just an offer of gratitude for the author and our testifiers today. You know, Representative, as you mentioned, this is a kind of issue that has been around, unfortunately, for quite a long time. And so I'm glad that in this legislature, we're coming together to find a solution to keep kids safe in their learning environment and other environments as well. And that this is an issue that folks are coming forward bravely and talking about so that we can do something about it. So I appreciate that. Thank you.
Representative Bennett.
Mr. Chair, Mr. Say thank you.
Thank you. Any other questions for the representative or the testifiers? Representative, Chair Moeller.
Thank you. Thank you, Mr. Chair. And I just, I think maybe we're missing the engrossed version, which adds in, does it have a different section 10? I think is,
Section has.
Mr. Debo.
Mr. Chair and members, yes, the bill was engrossed in the last committee, and so I was going off the document that was distributed today, but the first engrossment has a new section which creates a separate offense for persons who commit this proposed grooming crime as well as solicitation of a child, in a school setting, and if the victim is between the age of 16 and 18. The existing law applies to victims who are under the age of 16. So this would create a separate offense for school employees, staff, contractors who come in contact with the victim through their affiliation with the school, and they would be subject to penalty if they groomed the person, solicited the person, or used electronic communications to solicit the child. So that is part of the bill. I apologize, I was looking at originally the bill as introduced, but on the internet, they posted the first engrossment.
Chair Moeller.
Thank you, Mr. Chair. I just am glad we have that on the record, and I remember the bill looked a little different when I looked at it before, and I also just want to give my thanks to Representative Bennett and to the testifiers, especially for you for having the courage to share your story. What you're doing here is going to help so many other people, and so it just is, we're honored that you're coming to share that with us, and to you, Detective, too, for being persistent in closing loopholes that are in the law. So thank you.
So, Mr. Chair, can I?
Representative Pinto.
And thank you, Mr. Chair. And I just want to make sure I understood. So the first engrossment then is the same as what we have in front of us, just with that additional section 10 that's online. It's just unusual for us to have something in front of us that's different than the version that we're voting on. And so I certainly very much support the bill and echo the words of thanks to all three of the folks at the testifier table. Just want to make sure I was understanding.
Mr. Debo.
Mr. Chair and members, yes, so as far as it relates to the criminal provision, that's the most substantive change. There's a piece in there about the definition of a child that was added to conform to this to reflect that the age difference in the two statutes, where one applies to children 16 and under, and one applies to children up to the age of 18. But substantively, the key is the school piece.
Okay. So, Mr. Chair, I gather the first engrossment may just have not made it in our packets, I guess, is what we're saying.
Mr. Pinto, how about if we lay it over for a little bit and we can get updated copies and come back to it later in
Well,
the meeting?
and I certainly don't want to delay it moving forward. I mean, if we feel, I just want to make sure I'm just declaring what we're voting on, so. So either way, Mr. Chair, I'd be comfortable with proceeding, certainly if you and others would as well. I don't want to hold things up for the author and testifiers. I just want to make sure we were clear on it, that was all.
Getting a thumbs up from the co-chair. With that, I'd just like to say thank you, Representative, for bringing this forward. Think of a couple cases that I investigated. Thankfully, none of them were with a teacher, but the impact on the victim was still very, very profound and long-lasting. So the damage was done both by stepdads. So with that, Representative Bennett.
Thank you so much, and sorry that the engrossed version isn't in there, the one little component. We had to fill that gap in because law stops at the age of 16, and in our schools, it should go up to 18. So that's basically what it does. And thank you, and I know the next step for this is the Children and Families Committee. I'm hoping we will move this forward so we can get a hearing there, too.
Thank you.
Thank you. I renew my motion that House File 3489 as amended is re-referred to Children and Families Committee. All in favor signify by saying aye. Aye. All opposed say nay. Motion carries, and House File 3489 is re-referred to Children and Families. Thank you, Chair Bennett, and your testifiers. The next bill on the agenda is House File 3990. This is my bill. Representative Whitty will be the chair. Just give me a second.
Chair Novotny, would you like to move your bill before the committee with a recommendation that the House File 3990 is re-referred to the General Register?
Chair Woody, I would in fact like to move House File 3990 before the committee and recommend that it is re-referred to state government.
I see you have an amendment coded A1. Please explain your amendment.
Amendment 3-1 on line 1, page 9, we strike shall and insert may.
Thank you. Are there any questions, committee, for Chair Novotny on the A1 amendment? Chair Novotny, seeing none, moves adoption of the A1 amendment. All in favor, say aye. Aye. All opposed, say nay. Motion prevails and the amendment is adopted. Please begin your testimony, Chair Novotny.
Thank you, Chair Woody. Earlier this year in the off session, I was approached by MMB staff, and they wanted to talk to us about a problem that they had. It started when the Criminal Offender Rehabilitation Act of 1974 was put out to encourage and contribute to the rehabilitation of criminal offenders through employment. The law established that public employers cannot disqualify an applicant solely based on a criminal conviction. As the law has been understood, there was a process that allowed public employees to disqualify an applicant if their conviction directly relates to their job, and there's not sufficient evidence of the rehabilitation and present fitness for the position. However, a recent Court of Appeal decision in McNitt versus MNIT, interpreted the law to mean that if an applicant can produce certain documents outlined in the statutes, sufficient rehabilitation is established. And the public employer did not have any discretion to disqualify an applicant whose conviction directly relates to the position. In this case, an applicant was disqualified by Minute for an IT position within the Department of Education after a background check showed a conviction for possession of child pornography. The Court of Appeals held that once an applicant provides documentation listed in that statute, the applicant has satisfied the statutorily defined means of demonstrating rehabilitation and cannot be disqualified from employment. I'd like to note that the case was appealed through the Minnesota Supreme Court, and oral arguments were held September 8th, 2025. The court has yet to issue an opinion, but I feel it would be good for the legislature to get in front of this issue. Public employers are stewards of the trust and welfare of Minnesotans. Allowing a public employer reasonable discretion to determine an applicant's rehabilitation and present fitness to perform the duties of the employment sought will enable the public employer to consider the public interest in hiring decisions. This bill would clarify the law and restore a balance between providing second chances and allowing public employees appropriate discretion to make hiring decisions based on specific duties, responsibilities, and access of position. I have MMB Deputy Commissioner Blake Chafee with me today to go further into details on this bill.
Thank you. And Deputy, if you can just identify yourself for the record and you can give your testimony on the bill.
Certainly. Chair members, Blake Chafee, Deputy Commissioner of Minnesota Management and Budget.
You can go ahead with your testimony.
Oh, certainly. First and foremost, want to thank the committee for the time today. Want to thank Chair Novotny for his support of this bill. I think the chair covered it incredibly well. We're seeking to restore really narrow and reasonable discretion to allow public employers to, consider the specific facts of the crime and how that relates specifically to employment. And as the chair said, in the case before us, that the conviction related to child pornography, we really feel that it is reasonable for the public employer to say, this is a situation where we wouldn't want someone to have access to these sensitive systems, to these sensitive data about children. And so we would, are just looking to restore that, again, pretty narrow, reasonable discretion for public employees to consider how that crime relates to the specific job that an applicant is applying for and seeking.
Thank you. Committee members, if there's no other testifiers, any questions for the chair or the testifier? Representative Moeller.
Thank you, Mr. Chair, and I think Mr. Holquist is sending something your way. I am supportive of this. I do know this Chapter 364 is not one that we normally see, and especially with the change that we made with the amendment from a shall to a may, I don't really know what impact that has, and I'm hoping we can change the motion to send this to State Gov, just because this isn't a normal chapter of law that we see. Again, I'm totally supportive of it, but it would be more comfortable to me if a committee that maybe understands some of these chapters has a chance to look at it or at least waive it if they want.
Vice Chair Whitty, I didn't hear, which committee does she want it to go to? State Gov Finance. State Gov Finance. That's where I have it, it's going to. But I don't know what I said the first time. You had it going to the general register?
Oh.
No. So you okay, renew your motion to send it to State Gov Finance? I would like to remove my motion that House File 3990 is re-referred to State Government Finance. Great catch. Any other questions for anybody? Chair Novotny, any closing comments? I think this is a good bill. Obviously, when they approached me and told me the story about, a person with this conviction having access at that department, I thought that there are obvious things that some people should not have access to, and with that, I ask for a yes vote. Thank you, and with that, Chair Novotny renews his motion that House File 3990 as amended is re-referred to State Gov Finance. All in favor, say aye. Aye. All opposed, say nay. Motion carries, and House File 3990 as amended is re-referred to the State Gov Finance. Thank you, Chair Novotny, and to your testifiers. Oh, it's mine. What's your bill? I know where I'm going. What did I say?
I'm waiting for my testifier.
The next bill on the agenda is House File 3826. Vice Chair Whitty, please come to the table with your testifier. Vice Chair Whitty, would you like to move House File 3826 before the committee with a recommendation the bill is re-referred to State Government Finance Committee? That's my desire. Vice Chair Whitty, I see you have an amendment coded DE1. Would you like to move your amendment before the committee? Yes. Nonpartisan staff wrote to clarify the language from the bill as introduced. I'd like to move the adoption of the DE1 amendment. Can you explain your amendment? I'm going to have nonpartisan. Mr. Johnson.
Mr. Chair, members, the DE1 makes several changes to the underlying bill, some of which are technical, and there are a few substantive changes. The first two sections in the DE1 are different. This moves the administrative subpoena authority that was in the bill that would have been granted to the BCA and expands the existing administrative subpoena authority that exists for both the Attorney General and for county attorneys. Those are the first two sections. There's also some technical reorganization in Section 1 that would make the Attorney General's statute be structurally similar to the county attorney statute, just for ease of use. The third section begins at the bottom of page 3. This takes a definition that in the underlying bill was sort of embedded in the definition of identity, moves it out of that particular location and puts it in another location, which is just a technical change. It also amends some of those terms to more closely align with the existing terminology in our deep fake statutes. The final section, which is on page 5 at line 21, is a statute of limitations. This makes some changes that are mostly to conform the statute of limitations language to our existing structure. This establishes a 7-year statute of limitations for the listed offenses. This also adds the effective date that is commonly used when there's an amendment to the statute of limitations. This effective date would mean that if someone has committed one of these offenses and the statute of limitations has not expired, then that person would be subject to the new statute of limitations, which is longer. Those are the changes, Mr. Chair.
Vice Chair Whitty, I see you have a testifier with me. Is this Mr. Ofsted of the BCA Financial Crimes and Fraud Squad section?
Yes, and I was just going to give a little background on my bill.
Go ahead. We're on the amendment still, though. On the amendment, to your amendment. Would you like to speak to that?
No.
All right, all in favor of the DE1 on 3826, signify by saying aye.
Aye.
All those opposed say nay. Motion carries, and the DE1 is approved. Vice Chair Whitty, to your bill as amended.
Thank you, Chair Novotny, Chair Moeller, and committee members. House File 3826 is a BCA policy bill related to the work of the BCA Financial Crimes and Fraud section. The bill would provide additional tools to the BCA in its fight against all types of fraud in Minnesota. The bill expands identity theft to include AI or technology-based duplication of someone's likeness and extends the statute of limitations for some types of fraud related to crimes. This extension is important due to the complex nature of these crimes and helps ensure fraudsters are held accountable. I have Tony Ofsted from the BCA with me to provide more information about the bill.
Special Agent in Charge Ofsted, go ahead. Identify yourself and begin your testimony.
Thank you, Mr. Chair. Tony Ofsted, Special Agent in Charge. I oversee the Financial Crimes and Fraud section of the Minnesota Bureau of Criminal Apprehension. The amendment, or the bill proposed for identity theft, is really an attempt for us to catch up to technology, where we have been woefully behind when we look at AI and all the recent instances of deepfakes and what we're using in terms of our investigative ability to hold people accountable. And as we see expansion into things like synthetic identities and other things beyond our space, we don't have the laws in place to be able to hold people accountable. So this is an opportunity for us to advance beyond where we currently are and create legislation that affords us the tools in the fraud space and financial crimes sector specifically, but broadly across law enforcement, as we're seeing rapid advancement in the proliferation of AI and synthetic tools.
Thank you. Members, do we have any questions for Representative or Vice Chair Whitty or his testifiers? Representative Pinto.
Thank you, Mr. Chair. I think, Mr. Chair, I'd only just note, Mr. Ofsted and I are friends from high school. I didn't realize as you walked up there that I was going to be seeing you sitting there, so it's nice to see you. But my question is actually for Representative Whitty, or maybe just a note. I appreciate the DE1. One note is on page 3 of the DE1. I appreciate having the administrative subpoena authority for county attorneys and attorney general be expanded as opposed to the version of the original bill. But I would note that if you look at lines 3.22, this is in the original law, that administrative subpoenas for wage theft and welfare fraud and identity theft cases can only be issued if there's probable cause. And I guess I hope as the bill moves forward that the new language we've added about financial crimes and fraud, it seems like they should have the similar limitations as those in those other cases, as opposed to being just blanket any cases. The amendment was, I think, maybe right at the deadline, and we couldn't submit a secondary, but would ask that be something that would apply so that the ability to get records is not significantly broader than the current administrative subpoena statutes. I hope Mr. Chair, I hope you're understanding, and Representative Whitty understands what I'm saying. Thank you.
Vice Chair Whitty.
I do, and I appreciate you bringing that up, Representative Pinto, and definitely will look into it and understand what the intent is.
Okay, thank you.
That be all, Representative Pinto?
That was all, Mr. Chair, thanks.
Thank you. Any other questions for the testifier or Vice Chair Whitty? Closing comments.
Thank you for hearing the bills today, committee members. Since the bill is an agency policy bill, there is no cost to it. I renew my motion to recommend that House File 3826 is referred to the State Government Finance Committee. Thank you.
All in favor of Vice Chair Whitty's motion signify by saying aye.
Aye.
All those opposed say nay. Motion carries, and House File 3826 as amended is re-referred to State Gov Finance. Thank you, Vice Chair Whitty. Next on our agenda is House File 3827. Representative Duran, please come forward with your testifier to the table. Representative Duran moves House File 3827 before the committee with a recommendation that it is re-referred to Judiciary, Finance, and Civil Law Committee. Representative Duran, please begin your testimony.
Thank you, Mr. Chair, and thank you, committee, for allowing me to present House File 3827. This is a BCA policy bill designed to make technical corrections and clarify existing statutory language. The bill clarifies the legislative intent that reimbursements to local law enforcement for unanticipated long-term investigations are not subject to other grant requirements. It also updates language to reflect current practices and ensure the BCA is not the tool, or that has the tools needed to effectively correct record errors related to expungements under the Clean Slate Act. Finally, this bill ensures that all BCA receives necessary information in order to protect from the judicial branch to assist in effective enforcement of these orders. And then I have a BCA agent here to help out with clarifying their policy intent.
Excuse me, it appears that we have Deputy Superintendent of the BCA, Dana Goetz, with us today. Please identify yourself and begin your testimony.
Thank you, Mr. Chair and members. My name is Dana Goetz. I'm a Deputy Superintendent at the BCA, and I'm just here, this is the BCA's technical policy bill. There's 4 items that Representative Duran had mentioned. I'm happy to expand on any of those or answer any members' questions.
Members, any questions for Representative Duran or Deputy Superintendent Goetz? Closing comments. Representative Duran.
No, thank you for hearing the bill today, and since this is an agency bill, there is no cost to it. I renew my motion to recommend the House File 3827 is referred to Judiciary Committee.
All in favor of Representative Duran's motion signify by saying aye.
Aye.
All those opposed, say nay. Motion carries, and House File 3827 is re-referred to Judiciary. Thank you, Representative Duran, to you and your testifier. Next bill up is House File 3822, Representative Hudson. Representative Hudson moves House File 3822 before the committee with a recommendation that the bill is re-referred to State Gov Finance Committee. There is an amendment that has been filed with the bill, but we will consider the amendment after Representative Hudson has presented his bill in testimony. Representative Hudson, begin your testimony, please.
Thank you, Chair Novotny and Chair Moeller. You'll note that a fiscal note's being passed around to this bill with a cost of 0. House File 3822 makes a adjustment to the level of offense that's already codified in 609.43, misconduct of a public officer or employee. What it does is it says that a person who violates paragraph A may be sentenced to imprisonment for not more than 1 year or a payment of a fine of not more than $5,000 or both. So we're basically taking this from a gross misdemeanor to a felony for the 4 different circumstances outlined in lines 1.11 through 1.19 that, again, are not changing from existing law. This is simply an adjustment to the level of the offense and the consequences that would be endured by somebody convicted of committing this offense. I'd like to draw a particular note to lines 1.18 and 1.19 in the capacity of such an officer and employee that makes a return certificate, an official report, or other like document having knowledge it is false in any material respect. And this, of course, evokes the story that came out of KSTP on January 6th of this year, where the Minnesota Department of Human Services Commissioner said the agency's investigating after the legislative auditor found employees in the agency's behavioral health administration backdated or created documentation during an audit that focused on the management of taxpayer-funded grants. The revelation came during a nearly 3-hour hearing when Judy Randall, the legislative auditor, told lawmakers that her staff found multiple instances of what appeared to be an attempt to fabricate documentation that didn't previously exist. Randall described it as a systemic effort that she said she'd never seen in nearly 3 decades with the Office of Legislative Auditor. The quote was, "We have never been able to prove it, to document it, and we did in this case." I have not heard any updates from DHS regarding the outcomes of that investigation or whether or not there's been any appropriate disciplinary action, but we do have this statute on the books that specifically calls out what took place in that case as an example of something that should carry criminal penalties. And for whatever reason, those cases have, to my knowledge, yet to be brought. But if they are, that type of behavior, I think, is well beyond the pale of what's expected from the folks who we pay with taxpayer dollars to administer the business of this state. And I would appreciate the support of the members of this committee to update the consequences for this offense. Thank you, Mr. Chair.
Thank you. We have an amendment A1. Who has the amendment?
I do, Mr. Chair.
Chair Moeller, describe your amendment.
Yeah, thank you, Mr. Chair, and I do plan on withdrawing this amendment, but in looking at the language of the current law, and obviously applies to state employees, and I certainly, understand conduct that is troubling. But as I was looking at this, as we were talking about it, we recognize that we have an issue with federal agents not complying with what they're required to do under law. And I was especially thinking about what the judges have been saying to the attorneys who are appearing in ICE-related cases. I believe there are over 96 court orders that ICE has violated across 74 cases. There are particular cases where ICE, or where the judges said that people needed to be released on bond, and the federal employees said they just hadn't gotten around to that yet. Clearly, these are things that they are required to do, and they weren't. And so it just, again, just wanting to point out that this is an issue at the federal level right now. And with that, I will withdraw the amendment.
With that, Chair Moeller withdraws her amendment. Questions for Representative Hudson?
I believe there might be a testifier.
Stand by, we have a testifier. Devin Bruce, Legislative Director of Political Affairs at MAPE. Mr. Bruce, identify yourself and begin your testimony.
Thank you, Mr. Chair and members. For the record, I am Devin Bruce, the Director of Legislative and Political Affairs for the Minnesota Association of Professional Employees, a union representing over 18,000 workers across all agencies, boards, and commissions. I just want to thank you for the opportunity to testify and share some of our concerns around some of the language around the expansion of criminal liabilities contained in House File 3822. We also share the concerns that are highlighted in MMB's letter, particularly in your packet, such as the impact that this may have on state employees' rights to due process, as well as a fair investigation, as well as the progressive discipline structure that would more appropriately fit any of the alleged misconduct after the investigation. This bill, however, also jeopardizes some of the other things that we've been able to accomplish over the past couple of years in expanding some of the whistleblower protections, as well as creating stronger regulations and processes for our state employees to report and stop fraud. The number one question that we've been asked and that the public has asked is, whenever we have these hearings on fraud regarding some of the conduct from private nonprofit entities, is why did the agency continue to make payments if there were suspicions of fraudulent activity? And in some cases, like Feeding Our Future, employees did just that. They did stop payment only to be later directed to resume the payments and reimbursements amid sustained legal and harassment campaign by the organization. Under this bill, which an employee who attempted to do the thing that everybody is expecting and asking them to do and stop payment could then be subject to enhanced criminal penalties for failing or refusing to perform a known mandatory, non-discretionary ministerial duty of the Office of Employment. That is in subsection 1 of A under this provision. Over the past couple of weeks, we've heard many quotes pulled from Judge Tim O'Malley's report regarding the investigation concerning the culture of compassion over compliance, where top DHS officials ignored the program integrity concerns brought by employees and also whistleblowers that you've also heard in the fraud committee or that have heard from your own constituents. These rank and file employees would then be subject under this proposal to some of those penalties, and not the people who above them who may have directed them to perform this misconduct. It almost always falls on the rank and file employees and not the ones who are at the top. They always avoid accountability. And we undoubtedly know that this will also have a chilling effect on any more whistleblowers who would attempt to come forward to share their concerns because of the word felony. We've had this experience in the past, or fears of litigation being brought against them, or undue harassment. So we all have an interest in holding people accountable for their actions, particularly public employees. Any misconduct undermines the integrity of the programs that they're hired to perform and the investments that all taxpayers make in these programs and that they rely on. So we would appreciate that you take a much more narrow approach to this rather than broadly applying prescriptive punishments that would violate public employees' due process rights, as well as have serious chilling effects on any progress that we've made over the past couple of years. And thank you.
Representative Hudson?
Thank you, Mr. Chair.
You look like you have a thought.
Sure. In response to that, I'll just say it's a little bit difficult for me to follow the argument because there's no structural change to the underlying statute in terms of how it functions or what it is aimed at addressing. I was particularly confused by the statement within the MMB letter that says the statute covers many different kinds of conduct from serious abuse of power to, quote, procedural mistakes. I'm looking through the existing statute. I don't see any reference to procedural mistakes. Again, I will read off the 4 areas where this law would apply to you as a public officer. 1, intentionally fails, or refuses to perform a known mandatory non-discretionary ministerial duty of the office or employment within the time or the manner required by law. Or 2, in the capacity of such officer or employee, doesn't act knowing it is in excess of lawful authority or knowing it is forbidden by law to be done in that capacity. Or 3, under pretense of color of official authority, intentionally and unlawfully injures another another person's property or rights. Or 4, in the capacity of such officer or employee, makes a return, certificate, official report, or other like document having knowledge it is false in any material respect. Those are the ways you fall under this criminal statute that, again, already exists as a gross misdemeanor. There's nothing in here about making mistakes. There's nothing in here about making errors. There's nothing in here about being an imperfect human being who occasionally makes a typo. This is about knowingly and intentionally abusing your power as a public official. It's already a gross misdemeanor, and we are simply adjusting the seriousness with which we address that on the consequence side of the equation. There's really 3 areas that apply to situations like this. The first is investigations, and then there's oversight, and then there's consequences. This addresses the 3rd leg of that stool, which is the consequences. It also does not prohibit or interfere in any way with the progressive discipline structure, which of course is an employment concern as opposed to a criminal concern, which falls in a separate silo. If activity warrants somebody being dismissed, that's a separate consideration from whether they have broken the law.
First up for testifying is Representative Duran.
Thank you, Mr. Chair. Maybe this might be for Mr. Bruce, but I was just trying to figure out here, during your testimony, you said that if someone is mandated, like the rank and file person is mandated by an employer to do something illegally, what do you tell your employees? Because right now, I mean, what I've heard from you is that usually what happens is that order comes from the top and then it pushes down. Even though it may be illegal, the employee's still doing it. So I'm just trying to figure this out here. And through your testimony, it's a concern to me because I don't think that this bill says that your rank and file person has to violate the law. Actually, it's just saying it's more of an increasement of the penalty when someone knowingly violates the law. So I guess I'm a little bit concerned on the testimony here, and for the employees and obviously your people's safety, I want to make sure that they're not being forced into violating the law as well. Can you explain that a little bit for me?
Mr. Bruce.
Yep. Thank you, Mr. Chair and Representative Duran. My testimony in particular was on this, the broad construction, particularly under section or subdivision 1 of section A. And because that is a ministerial required duty, so it's essentially what your job performance would be. In many cases for our employees who are administering grants, it's remitting the money. So if there are broad concerns and they aren't being listened to, this culture of indifference or noncompliance is allowed to permeate through some of the agencies, or at least in part with some of the supervisors. If they are told to do something, they either face discipline for, in some cases it would be, I'm trying to think of the word. They would face discipline for not following direction or from their supervisor, or in this case, if they knowingly do it, there might be some type of other consequence, in particularly like a felony. We've seen areas where it's pretty gray in the past, and we've done a lot of work to try and clarify where state employees can refuse to remit certain grant payments to either legislatively named grantees, or in other cases, places like Feeding Our Future or some of these others that have been named, where they have some suspicion of fraud or some concerns that the paperwork is not being submitted on time and they're told to do it. If they refuse, then this statute says that they aren't performing their ministerial duties and could be subject to punishment.
Representative Duran.
Thank you, Mr. Chair. This next question's or thank you for that explanation. I don't know if the bill does that. But Representative Hudson, what is changing in this bill?
Representative Hudson.
Thank you, Mr. Chair, and thank you, Representative Duran. I appreciate that question. The structure, whether we agree with it or not, that's been referenced in lines 1.11 and 1.19 is not changing under this bill. It's an existing structure. So if it is indeed too broad, then I guess we need another bill to address how broad it is. I don't believe it is too broad. What we are changing in this bill is the severity of the consequence for being found guilty of this criminal provision, misconduct of a public officer. And I'll also just note, in reference to the suggestion that this could suppress a state agency employee from taking appropriate action in circumstances where they suspect fraud is taking place, a couple of things. First of all, the language is very clear that known intentionally, there's an intention here to do something that's illegal, that's unlawful. If there's ambiguity in the context of instruction you've been provided from a superior as to what your appropriate ministerial duties are, I have to believe that both prosecutors and judges would take that ambiguity into consideration as they adjudicated a claim that a public officer was guilty of this particular criminal conduct. Secondarily, in my role on the House Fraud Prevention and State Agency Oversight Committee, I and my fellow members have been privy to multiple whistleblower complaints. And of course, we have Faye Bernstein, who's come out publicly and put her face and her name to very alarming accusations of retaliation for doing precisely that, for saying, hey, there's red flags here and we need to do something about it. I have yet to encounter a single whistleblower who said, you know why I'm a little anxious about coming forward with my observations? It's because of 609.43. It's because I'm afraid I'm going to get convicted of a gross misdemeanor for telling you that fraud is happening. It's never happened in my experience. I do not believe that this statute, as it exists today, is any factor in whether or not a state agency employee is going to come forward. What we've heard from them directly is that the actual factors affecting whether or not they're willing to come forward or put their name and face to their claims is the fears of retaliation that they will get from within the state agencies.
Representative Duran.
Thank you, Mr. Chair, and thank you for that clarification. That this bill is not actually changing the structure, the statute that's actually in place right now. It's actually just increasing the penalty of someone that's knowingly created a criminal action already. So, I mean, it's pretty simple, pretty clear, and I think we all should be able to support this. Thank you.
I will just say, my daughter used to play volleyball, and they had a rule in volleyball is that if there's any question if the ball is going to be in, it's in. You don't take a chance and you report it. And I think that, if there's a chance something might be illegal, it's illegal. Representative Rapinski.
Thank you, Chair Novotny. I kind of listen to what you say to our testifier. You use the term above them that may have directed them, and you use the example of feeding our future. When you use that example, and you talked about payments were cut, and then payments were then reinstated, I guess I'm assuming that came from above them. Have they been able to identify who instructed them to reinstate it or why they were reinstated after they were kind of found to be fraudulent to begin with? Have they been able to properly identify that chain of command, or, as you said, above them may have directed them?
Representative Hudson.
I believe the question was directed at the testifier. I defer to the testifier, sir.
Mr. Bruce.
Thank you, Mr. Chair. And Representative, there has been numerous conflicting accounts, but from what was at least stated from the judge who oversaw some of the case filings, that there were settlements reached between the agency and also the recipients of the grants when there were discrepancies. So at some point, it was either settled outside of court, pending a court filing. But in some instances, there was also reports that during some of the hearings, the judicial officer instructed the grants to be turned back on. And so that's where we see some of these conflicting accounts, and our employees then just do their job as they're supposed to.
And if I may add,
Representative Hudson.
Mr. Chair, I very much appreciate that point being brought up, because indeed, specifically with Feeding Our Future, the reason why the payments were restored was because of a court order, as the individuals involved who would go on to be indicted and convicted in that scam were actively litigating against the state agency.
Mr. Rapinski.
Thank you very much for that. And knowing my constituents, one of the biggest questions I receive is what is going on with all the current fraud that's being explored and being whistleblowed upon, and who's being held accountable for that. And I do believe this bill is a good measure to help in that. So I am supporting this bill, and thank you, Mr. Hudson, for bringing this forward. Thank you.
Representative Curran.
Thank you, Chair, and thank you, Representative Hudson. Just a couple questions. I'm looking at how the current statute is used, and sort of looking at how the makeup of cases that have been charged versus cases that are convictions. I'm not seeing a ton of information on anything related to fraud. I'm curious if you have had conversations with, I know we had one union rep is here with MAPE. Have you had conversations with law enforcement associations, MPPOA, LELS, chiefs, sheriffs about this bill?
Representative Hudson.
Thank you, Mr. Chair. Thank you, Representative Curran. No, I have not had any conversations about this specifically, because we're not dealing with any substantial change to the existing structure of the statute, just the criminal penalty.
Representative Curran.
Thank you. And yeah, I think they might have some opinion on this. I guess we'll find out. But when looking at the 12 convictions under this statute that have happened over the past 5 years, 6 of them are convictions for on-duty officers. And with an increased penalty to a felony, some things like misusing a city-issued credit card or looking up a woman at their gym, that would bar them from having a firearm for the rest of their life. And so I'm curious if law enforcement is present, or if they might have an opinion to offer, if they're comfortable knowing that half of the cases that are charged involve some of their members, and they would lose the ability to carry firearms for that.
Representative Hudson.
Thank you, Mr. Chair. Are there any such individuals who could testify to that? I'm not seeing any. So what I'll say is, from my perspective, I couldn't possibly care less, right? If they're guilty of those offenses and that's the consequence under the law, they should endure the consequence.
Representative Curran.
Fair enough. Thank you.
Representative Tabke.
Thank you very much, Chair Novotny. I, too, when I heard about the news of the DHS employee, I was extremely concerned about that. It is a big problem that we need to be making sure goes through, and so I scheduled meetings to talk through it with folks and find out what is happening from a state level, how it didn't, because coming from a city background and having been mayor, like it would have been very much handled quickly, and I wanted to make sure that the same kinds of things were happening at the state level. And so I had a meeting with the legislative auditor a couple weeks ago to see if there's any legislative changes that we needed to make in order to make sure that if this kind of thing happens again, that we have activities in place to take care of it. And so from my personal perspective, I'm waiting to see what happens with this and how it moves forward. So I'm just going to let you know, from the beginning of your testimony, you talked about how you didn't know where things were at on that, but I just want to let everybody know that what DHS, as they've reported multiple times on the 18th of December, they learned about it. The evening of the 18th, they met with OLA to discuss the issues. The 19th, they worked with the compliance office. 23rd, they started the investigation, developed a plan. So we're in phase 2 of the plan right now and I think that employees deserve due process and making sure that we're getting through things. So I don't support what you're doing in the bill here today, but if you have other ideas and want to work on things, would be happy to work on them with you and find a way to get forward, because this kind of thing, absolutely, I agree with you entirely, should not happen. I just don't think this is the right fix for it, so thank you.
Response?
Thank you, Mr. Chair. I'll just point out that, again, citing the KSTP story, Judy Randall, the legislative auditor, told lawmakers that her staff found multiple instances of what appeared to be an attempt to fabricate documentation that didn't previously exist. Randall described it as a, quote, systemic effort, unquote, that she said she'd never seen in nearly 3 decades with the Office of Legislative Auditor. To me, that suggests this was not one bad apple. Systemic efforts are not one bad apple. And so it does raise the specter of, how are we here in March and we still don't have an update from DHS as to, first of all, who was responsible, whether or not they've been disciplined, or apparently any effort to pursue criminal charges under the existing 609.43 statute that we have currently, which is available. They could be brought up on gross misdemeanor charges right now, and likely properly should be. And perhaps the reason there's been so few cases historically is because it's a gross misdemeanor. We do know that prosecutors take the level of the offense into account when they use their discretion to determine whether or not it's worth their time.
Vice Chair Feist.
Thank you, Mr. Chair. I'm looking over the statute and just thinking as an employer about line 1.16, so just the original underlying statute that this would cover, where somebody can intentionally injure another person's rights. And that just is so broad. I honestly don't know if that should exist at all. It seems like incredibly broad, and just employment law is so messy. So I think, a manager who hurts somebody's feelings and they feel like those feelings were their rights, and then, something where it's just like maybe some poor communication skills or miscommunication and lots of feelings becomes a felony. And that seems like wildly outsized consequences for just kind of maybe being a crummy manager. So yeah, just taking it out of the realm of all of the bigger picture questions, I just think that the felony consequences for a scenario like that seems outsized to me. Thanks.
Representative Hudson.
Thank you, Mr. Chair. Thank you, Representative Feist. I certainly hope and trust, actually, that our judicial officers are not so subjective and loosey-goosey that they would take a hypothetical like that and regard it as an actual intentional violation of some person's rights. But again, we keep going back to lines 1.11 through 1.19, which again is underlying statute. And I do appreciate the fact that changing the gravity of the offense changes the dynamics of how it's applied and perhaps how often it might be applied. But if we need to take a look at the underlying statute in order to refine definitions, I think that's a task for another bill.
Vice Chair Feist.
Thank you.
Chair Pinto.
Thank you, Mr. Chair. Representatives and members, I've made the point in a couple bills that we need to be thinking about how the penalty for a given offense kind of fits in the broad structure of offenses, right? So under current law, an assault against a family or household member is a misdemeanor. So a domestic, and we obviously in this committee taking domestic assault very serious, it's a misdemeanor. We say in our current law that a public officer or employee who does one of these things under current law, and has been noticed, very broad conduct, a lot of different things could fall in. That's a gross misdemeanor, because this is a public trust that public officers and employees hold. So already when somebody does this, it's quite a serious offense. If there are 2 domestic assaults, that's a gross misdemeanor. That's equivalent to what the current law is. I get concerned about increasing the penalty to a felony. In part, what it does is then devalues other felonies. So we're saying that this broad conduct, so again, the misuse of a credit card, which is just one example from the list that we have, that is more serious than assaulting a family household member multiple times. It's more serious than a non-consensual sexual contact, which is a gross misdemeanor. It's more serious than indecent exposure. It's more serious than torturing an animal that does not die. Representative Hudson, you made the point that well, maybe one part of the reason that there are relatively few, or you'd think there might be more prosecutions if this is made a felony. In my experience, it's the exact opposite. Felony has a 12-person jury. Misdemeanors, gross misdemeanors have a 6-person jury. And to charge a felony, that's a very serious thing as well. It should be. In my experience, it's actually much more common. When in doubt, you're going to be able to go with a misdemeanor, gross misdemeanor. So I think you're going to find it's going to be less often that this is going to be charged once you make it a felony. More than half the people charged or maybe convicted of this crime were first responders. Most of them police officers and also firefighters. So, we could impose more felonies on first responders if that's the point here, because that's what the situation has been. Again, misuse of a city-issued credit card. Somebody who applied for a job interview and falsified the licensing certificate when they did that. That's a firefighter. Now, is that misconduct? Absolutely. And is that worthy of a criminal conviction? Absolutely. Is that more serious than non-consensual sexual contact? Is it more serious than repeatedly assaulting one's romantic partner? I don't know that it is, when you look at all the consequences of a felony. And again, every time we make something a felony, it makes the current felonies be worth a little bit less. And so we want to think about whether we want to do that. So given how broad the language is right now for ways to violate this statute, and a reminder, if fraud is committed, if theft is committed, there are separate offenses to charge that, depending on the value and all kinds of things. So there's many other ways to charge somebody with a crime and to have them be convicted of a crime. So this is separate from that. So is this conduct well situated in our framework of offenses? I would argue that it is, and that making it a felony would not be appropriate for what is listed here when we're just considering those particular situations. If there's something that violates another statute as an offense, then we treat that the way that it is. But we want to be very, very careful making things felonies along the way. So I appreciate your intent here and absolutely recognize the public trust that these folks hold, and they should be held to a higher standard, and in fact, they are. Which would go after anybody who's misusing their office, as the law currently allows. Thank you, Mr. Chair.
Thank you, Mr. Pinto. And before you get a chance to respond there, Mr. Pinto, with great responsibility comes great penalty. So higher penalties, as you said. A lot of public safety officers, police officers are responsible for getting charged under this bill, and if they have, they should. Representative Hudson.
Thank you, Mr. Chair. Thank you, Representative Pinto. I'm not sure I agree with the premise that there's some sort of metaphorical limited pool of seriousness, and that every time we create a new felony, we diminish the total capacity of that pool, and all other felonies are suddenly less serious because we recognize a new crime. I don't follow that logic. I think what we do is we look at the individual conduct, and we determine how serious that conduct is in its context, and then come up with penalties that are just and that will tend to result in deterring that conduct from recurring in the future. And as Chair Novotny and you yourself, Representative Pinto, noted, we properly should take into consideration the power differential, the power that people have been entrusted with, the public trust, and an abuse of that, I think properly ought to be regarded as a higher violation than if a similar crime was committed by somebody who lacks that power and lacks that authority.
Chair Pinto, are we done?
Mr. Chair, maybe I'll just note that, and my point is that it already is treated that way. It already is treated more seriously. And so then the question is, do we want to treat it sort of double more seriously? And at some point, I think we say, hey, we are treating it more seriously. It fits in our framework of crimes. It's appropriate. We can obviously agree to disagree on this, but that'd be the point I'd make. Thank you.
Representative Pinto. We've got a list, Representative Rabinsky. Representative Johnson.
Thank you, Chair. First, I just want to say thank you to the testifier for coming up and being here, advocate for the folks that you're representing and the workers that are, the vast majority of them, doing the right things. And to that point of public trust, I've been a union officer for a long time, and I've told my members, because there are conversations that I've had with attorneys and issues I've had with grievances and arbitrations, where police and fire are often held to a higher standard because of that trust that we talk about. But when I also represent my members in different hearings regarding conduct or things that went wrong, the question I always ask is, what are we trying to do here? Are we trying to penalize the person and make an example out of them? Or are we trying to change the conduct so it doesn't happen again, whether it's them or somebody else? And what I always try to do is figure out how we change that conduct, because I don't want to continue to be in that room and continue to have those same arguments. And when I look at the current statute, the tools are there. The tools are there to try them, to hold them accountable with gross misdemeanors, and for some reason they are not being used, right? So we are not changing it to a felony is not going to change the conduct. And I've heard it in a bunch of different committees that criminals are going to be criminals. If they don't care about the penalties, they don't care about this or that, criminals are going to find a way to be criminals. And if somebody is going to violate a policy or do something like that, I think figuring out how we address it on the front end is going to be way more productive in how we deal with it on the back end. So I guess if I'm going to try and boil it down to a question, the tools are already there and they're not being used, or they're not being used successfully. So how does just changing it from a gross misdemeanor to a felony actually solve any of these problems?
Representative Hudson.
Thank you, Chair Pinto, and thank you, Representative Johnson. As I noted, this is not a comprehensive overhaul of how we deal with these issues, such as the one that's described in the KSTP article. There's three broad silos. There's investigations, there's oversight, and then there's consequences. And what you're speaking to, and I absolutely agree with you, there's something wrong with investigations and there's clearly something wrong with oversight if we're not seeing the current underlying statute applied to circumstances which it was very obviously and directly authored to address. And I don't have the answers to those questions, and this bill does not provide an answer to that question. When we're considering consequences, it's a question of how seriously do we take this offense? And when I look at what was reported earlier this year, a systemic effort to attempt to fabricate documentation within a state agency, that's pretty dang serious. And when we're considering what the consequences for that ought to be, to my mind, making it a felony is appropriate.
Representative Johnson. Okay. Is there anyone else who would like to have a question for Representative Hudson?
What's up, Mr. Chair? Can I just ask one more question, Representative Hudson?
Chair Pinto, go ahead, and then I remember.
My only question is, Representative Hudson, why stop at a 1-year, $5,000 felony? Why not make it a 5-year, $10,000 felony, or a 20-year, $40,000 felony, or a 100-year, $1 million felony? Like, I mean, once you're gonna, I mean, yes, it's really serious. So, like, how are you choosing where to even stop?
Representative Hudson.
Thank you, Chair Novotny and Representative Pinto. It sounds like a deep philosophical question. How do we ever decide what penalties should be? And to your earlier point regarding, you know, the concept of felonies being in this kind of grouped category of mutual seriousness, I don't know that that's ever, and I could be wrong, but I don't know that that's ever been the approach that people have taken in bodies like this to determining what a sentence properly ought to be. You want to have a conversation about it being higher? I'm open to that conversation. I just think the current status of it being a gross misdemeanor is inadequate.
Thank you.
Representative Rapinski, did you have a quick question?
I do, Chair, thank you. I'm just listening to Representative Pinto over there. I'm curious if at some point maybe is his thought line of like the first offense would be a gross misdemeanor and then following offenses could be felony and the following offense could be potential longer sentence time? Is that what you're kind of getting at there? Is that like what you're supporting or was it what I didn't quite, I want to make sure I'm following exactly.
Chair Pinto.
Thank you, Mr. Chair. So Representative Rubinski, yeah, I could imagine that could totally make sense. Yeah, I mean, as it is right now, somebody has multiple offenses, they do stack on top of one another, right? You end up getting additional criminal history points, you end up receiving a longer sentence. So yeah, potentially, basically what you want to do is look at the nature of the offense and then compare it to other offenses and find a penalty that fits. So I could certainly imagine that potentially a second offense could make sense. In this case, what it's saying is that that first offense is a felony, and then it goes on from there. Sure. And that, to my mind, is inconsistent with the other offenses that we have.
Representative Rapinski.
Okay, thank you.
Thank you.
Representative Steer.
Thank you. Thank you, Mr. Chair. I kind of like the year and billion-dollar felony. That would be nice. With that, I request a roll call.
Representative Steer has requested a roll call. Roll call being requested, one will be granted. Vice Chair Whitty? Good. Passing. Co-Chair Moeller.
Thank you, Mr. Chair, and appreciate the discussion and certainly agree that the article describes very troubling behavior. I am curious, Representative Hudson, if you have any examples of this beyond this, what's mentioned in the article with the DHS employees?
Representative Hudson.
Thank you, Chairs Novotny and Moeller. The specific context described in the KSTP article, I'm not aware of other instances, and in fact, the article has the quote from the Office of Legislative Auditor Judy Randall, who says that in her 3 decades, she's never seen anything like this before. What I will say is that I think it's reasonable to insinuate that for something like that to happen, again, a systemic effort to fabricate documentation, one could reasonably ask the question, under what sort of culture does that take place? And whatever the answer to that question is, how pervasive is that culture? Does it cross agencies? And how much stuff is going on below the surface that we are not currently aware of?
Chair Moeller.
Thank you, Mr. Chair. Well, you know, again, I understand what you're trying to do, but also with respect to DHS and those employees, this law can't be retroactive. That would violate the Constitution. So the effective date applies to crimes committed on or after the effective date. And so it couldn't even be applied to the situation that you're, wanting to get at here. And agreeing with my colleagues that say making it a felony certainly doesn't make it more likely to be charged. I actually agree with Rep. Pinto in my experience as a prosecutor. I think it would make it even less likely to be charged. And in particular, when we look at some of the cases, and a couple of my colleagues have mentioned these already, where there has been a conviction, we've got a case where a sheriff's deputy used the CJIS database to improperly access information about another deputy and an incarcerated person. That deputy was convicted. We had another case where a county employee was tasked with determining which citizens are eligible for government assistance, deleted dozens of voicemails and emails from those seeking assistance, seeming to ignore them. Both of those incidents are bad. They're not good. But I don't think either of those things should rise to the level of a felony. And I'm actually reminded in reading that last example of a situation where when I worked at a public law office and we had an employee who she got overwhelmed by all the mail coming in, and I'm old, and this is before we had so much electronic filings, but she got overwhelmed by all the mail coming in and just started putting it in a filing cabinet. And when she actually left the job, someone found all of this mail. And these are court cases, you know, that was pretty serious. And I really think for her, it was a matter of anxiety or a mental health issue. I certainly don't think that should rise to the level of a felony either. So for all of those reasons, I just don't think that your bill here is really getting at the conduct that we all don't like and want to solve. Thank you.
Thank you, Chair Moeller. The points you brought up, the examples you brought up are exactly why I think this is a good bill and why the increased penalties should be there. You talk about the deputies that were accessing information that they knew they weren't supposed to access and for the wrong reasons. There are certain penalties and prohibitions that kick in when you have a felony conviction, and maybe that's what it'll take to get their attention. Maybe they don't get prison time, but they'll still have that conviction and the restrictions that come in because of that. Closing comments, Representative Hudson.
Thank you, Chair Novotny, and thank all of the members for a robust conversation about this issue. As far as the effective date and it not directly addressing the alleged conduct from earlier this year, I don't think there's anything particularly unusual about that. We write laws in response to things that have taken place in the past that will not go back in time and fix those things all the time. We did it earlier this week, and appropriately so. Beyond that, I feel as though, you know, we've worn the topic pretty well through. The last thing I will note is that if it sounds like there is a potential appetite to take a look at this specific type of conduct that's noted in the KSTP report. So if this simple change is inadequate and there's something more comprehensive we can do, whether it's in this statute or another, open to that conversation.
The roll call having been requested, the clerk will take the roll.
Novotny.
Aye.
Moeller.
No.
Whitty.
Aye.
Feist.
No.
Berg.
No.
Bliss.
Aye.
Curran.
No.
Jurin.
Aye.
Engen is absent. Greenman.
No.
Harder.
Aye.
Hollins.
No.
Hudson.
Aye.
Johnson.
No.
Pinto.
No.
Ream.
No.
Rapinski.
Aye.
Schwartz.
Aye.
Steer.
Aye.
Tapke.
No.
There being 9 ayes and 10 nays, the motion does not prevail. The last bill on the agenda is another agency bill, House File 3825. Representative Rapinski, please come to the table with your testifier. Representative Rapinski moves that House File 3825 before the committee with a recommendation that the bill is re-referred to Judiciary, Finance, and Civil Law Committee. Representative Rapinski, please begin your testimony.
Thank you, Chair Novotny. I was able to secure what I believe to be some of the best chocolate chip cookies made on this earth from Representative Cal Warwith's daughter, Isabel. So I do start them. They're going around. Please enjoy them. Chair Novotny, fellow reps, I would like to move House File 3825 before the committee and recommend that this bill is re-referred to the Judicial Committee. House File 3825 is a DPS Office of Justice Programs Policy Bill. The OJP division at DPS provides leadership and resources to reduce crime, improve the functioning of the criminal justice system, and assist crime victims. House File 3825 makes few technical corrections and enhances crime victim rights by ensuring victims are notified of plea hearings and sentencing hearings, protecting victims' identities in certain prosecutor petition documents, and requiring that victims be notified if an offense is eligible for automatic expungement. This bill provides important protections for crime victims in Minnesota. I have with me OJP Director Kim Babine to provide more details on the bill if any questions arise. Thank you, Chair.
Welcome to the committee. Please identify yourself and begin your testimony.
Good afternoon. Thank you, Chair Novotny, Chair Moeller, members of the committee. My name is Kim Babine, and I am Executive Director of the Office of Justice Programs. As Representative shared, we have a few technical pieces and a few pieces related to crime victim rights. Mr. Chair, would you like me to go into more detail or just wait, be present for questions?
Is she done? Okay. I'm sorry, what? Oh, yes, we have time. Go into
Okay.
detail.
Okay, sounds good. Thank you, Mr. Chair. Okay, the first item, and I'm going to go a little bit out of order. I'm going to cover the technical pieces first. Section 1, this proposal would eliminate the requirement that the victim be specifically identified in a prosecutor's petition for a sentence adjustment. Currently, the statute requires the victim's name to be included in the petition for sentence adjustment, and under this proposal, the prosecutor will still have the responsibility to notify the victim, but that victim identity, or they won't have to include the name of the victim to protect the victim's identity. Section 2 would expand the protections over victim identity to include the crime of using a minor in a sexual performance. The purpose is to protect the identity of minor victims of crime related to sexual assault, abuse, and exploitation. The use of a minor in a sexual performance is a crime that falls into the category of crimes, and we need the victim protection added. So now skipping to Section 5, this is a protection against employer retaliation. This would expand the protection against employer retaliation provided to victims of violent crimes to include victims of stalking. The crime of stalking is consistent with other crimes listed under the definition of violent crime. All right, skipping to Sections 3 and 7 is about automatic expungement. This proposal would expand the circumstances where the prosecutor is required to notify the victim that an offense is eligible for automatic expungement. Currently, when a prosecutor notifies the victim of the contents of a proposed plea agreement, they must also notify the victim of the eligibility of the offense for automatic expungement. There is no similar notice requirement for situations where the outcome of a case is a conviction or dismissal in the absence of a plea agreement, or if the defendant is acquitted. And then the last piece is outlined in, or refers to Sections 3, 4, and 6, and this is ensuring victim rights at plea and sentencing hearings. This proposal would establish a procedure during the plea and sentencing hearings that places a requirement on the judge to inquire of the prosecutor if the victims have been notified of the hearing, are present, have received their statutorily required notifications, and wish to be heard. The purpose of this proposal is to ensure that crime victim rights and presence are recognized in the courtroom, and that those that wish to have input, whether objecting to a plea agreement, providing a victim impact statement, or having their positions conveyed to the court through the prosecutor, are given that opportunity. Thank you, Mr. Chair.
Thank you. Questions for the testifier or Representative Rapinski? Vice Chair Feist.
Thank you. I was just curious what the process was for developing these recommendations. They all sound good. Although at first I thought you were saying that they should notify every single victim when there was an automatic expungement, and I was like, how? But then I understood it. So, but I'm just curious kind of what your process was for developing the proposal. Thanks.
Director Babin.
Mr. Chair, Representative Feist, thank you for that question. We have a number of different methods for getting input on crime victim rights and the crime victim statutes. Our Crime Victim Justice Unit, Director Suzanne Elwell is with us today if you want more specifics, but is in constant communication with prosecutors and other partners about the crime victim notifications and how those are working or not working in the field. We also have close relationships with the 6 crime victim coalitions, and we hear through them if there are pieces that may be omitted or things that might need more clarification in the statute. I think those are the 2 major ways that we get information, particularly for the crime victim statutes.
Thank you.
Vice Chair Feist.
I'm good, thank you.
Representative Rapinski, closing.
Thank you, Chair Novotny. Thank you for hearing my bill today. I renew my motion to recommend that House File 3825 is referred to the Judiciary Committee.
Representative Rapinski moves his motion that House File 3825 be referred to judiciary. All in favor signify by saying aye. Aye. All opposed, nay. Motion carries, and House File 3825 is re-referred to judiciary. The next meeting of the House Public Safety Committee is Tuesday, March 17th, 2026. Chair Moeller, you will have the gavel. There being no further business before the committee, the meeting is adjourned.